Good evening to one of the present here. V2 Legal is a law firm founded by Dr. V. Venkatesan with the motto Lead the Leaders. With a multifaceted approach in the legal field, V2 Legal is involved in conducting and defecting legal cases across the country, apart from offering legal advisory consultancy to various corporate companies, educational institutions, media houses, individuals, and also conducting pro bono cases. This is largely possible with the eminent team of lawyers in the V2 legal firm. The managing partner, with an experience of more than 26 years leading the law firm and also practicing as a legal professional in various branches of law and having served as a senior center standing counsel, is also an orator and has been a guest for prestigious law university, sharing the dais with eminent judges of the country. We are aware that dissemination of knowledge through various sources that are available in internet and other legal mediums, including classrooms, in order to give a professional experience and practical approach, V2 Legal Firm has endeavored to reach law students, research scholars, legal practitioners, legal enthusiasts. The entire legal team has put their fullest efforts to do their research on the topic of elections. Yesterday, we had the first session on the topic. Today, we are continuing with the sessions on the topic. We welcome our sir, V2 Legal Managing Director, Dr. V. Venkatesan, sir. Take the dais.
Welcome back. We had the first session of our webinar on election yesterday, and in continuation, I'm very glad to be presenting to you on the topic of election. Now, the 18th Lok Sabha election is on the way. All of us are going to vote on the 19th of April 2024. And the main object of this webinar is to make 100% polling in this Lok Sabha election. As an endeavor, V2 legal team has taken the task of doing this webinar on meticulous preparation for the topic. And yesterday we saw a certain subject on the elections as a recap. I'll go through that first, and then we'll continue with the subject of. So we stopped yesterday with the electoral bond scheme, and before that we stopped yesterday. And let's have a recap on the subject. See, I said the Constitution gives the strength for the entire activity of the government, and that is the backbone of our democracy. The preamble is very important. I said sovereign, with India as a sovereign, socialist, secular, democratic republic. That's why people are the champions and people are the king of this country, and they decide their leaders who should govern them. On that basis, then again, what is election, and what is the necessity for election, and under the Constitution of India, what are all the articles which touches upon the electoral process, like the election for the president, vice president, the Lok Sabha elections, for the legislative assembly elections, as far as the panchayat, municipalities, corporation, what are all the articles that are involved, and where do they get the source? What do the 7 schedules say about the union list and also about the state list on election? We saw that yesterday. And thereafter, who will be conducting the election? What is the power of a chief election commission and chief election commissioner, and how he is appointed, under what article, how the president is appointing the commissioner, chief election commissioner of India, and his term of office for 6 years, and all those things we saw that. And then thereafter, what are the powers, panchayat, municipality, and cooperative society elections, how they were by the state election commission, by the state election commissioner, state election commission under supervision of CEC. And then the parliamentary constituency, what will be the size of it, and how they determine about the parliamentary constituency, how often it is changing, and what is the delimitation process, delimitation commission, and how often the census is being taken. Based on the census, the parliamentary constituency will be decided, whether it is SC constituency, ST constituency, without compromising on all that, then we may not be able to approach the courts for that delimitation process. And then about how to register a political party before the Chief Election Commission under Section 29A of the Representative of People Act, RP Act, and then about which is a registered party, which is a registered unrecognized party. Then to secure the same place as the registered party, how much of votes a party has to secure, what is a national party, what is a regional party, and then we saw about the symbols, how symbol is important, what are all the three symbols, how long the recognized symbol can be retained by the political party, whether it is national party or by the regional party. They have to secure at least 6% of vote to retain that. And then about filing of nominations for both the Lok Sabha seats as well as for the legislative assembly seats, how this Form 26 plays a vital role, what are all the ingredients that are required to be filled, the 5 years of income tax, and then the property details, movable asset, immovable asset, loans, commitments, educational qualification, and then the number of cases, criminal cases. The political party also needs to file it before the Chief Election Commission, and then what is the importance of Form B, and then going to the next, who are all the voters, what is the voting age, that is 18 years of age, who has attained can vote. NRIs, if they have not got the citizenship, they may vote. The foreigners will not have any vote. And then what is the impact of MOTA, and then what are the patterns we have been following in India. First we had postal ballot, now then electronic voting. At present, we are using electronic voting machine EVM with VVPAT, that is voter verifiable paper audit trail. For this 18th Lok Sabha election, we are going to use only VVPAT. And then about the importance of the machine and how much it is costing, and in 2014, from 2014 onwards, they have been using it. One VVPAT machine can record up to 2000 votes. That is called one booth. One booth will consist of a minimum of 2000 votes. It be varying from 1010 to 1500. And then we said whether a candidate, if he is a candidate within the election time, if he dies, what is the position? Then the election itself will be postponed for reasons. If it is recorded by the RO, and then who is an election agent, who is a booth agent, and how many constituencies can a person contest? We said it is 2 constituencies, if it is assembly or whether it is parliament. And then we went up to spending pattern, how they spend money for the elections. Chief Election Commission, how much they have spent the money for the elections. In 1952 was the first election in India. It went for 4 months. India spent about, Chief Election Commission, it spent about 10 crores or 45 lakhs. Then in 2014, it spent about 55,000 crores. And now it is expected to cross more than 1 lakh crore. The amount has not yet come, but it is expected out of that. See, on this subject, there is an interesting judgment which I came across. So I also thought I will share it. Yesterday we shared it after the end of the show, end of this presentation. The PPT presentation, the entire content what we prepared will also be circulated, so you'll be able to have a look on this. And then what is how much of the money can be spent by a candidate if he is contesting for Lok Sabha elections. This 95 lakh as of today, and in the 1952 election it was 25,000, and for legislative assembly it was 10,000, and the state election it is 40 lakhs fixed today. It will vary a little lesser depending on the size of the state, size of the constituency. And then we saw about the funds for election. How do they get the funds? And under what provision of law? That is the Representation of People's Act 29B talks about the entitlement for fund, how a political party will be able to get the fund. They have to give a receipt. If it exceeds 20,000 rupees, I think it is wrongly 50 lakhs, 20,000 rupees, then they have to give the accounts to the income tax department. And then 29C was introduced in the later stage in 2016-17. 29C was introduced, and this is what is challenged before the Supreme Court. We'll come to that later. And then 29A, registered political parties are entitled to accept contributions. I think we stopped there yesterday, where we said 29A, a registered political party, that is any political party which is at their national or regional political party, whether it is recognized or not. 29A is the section which is concerning the registration of a political party. And then prior to 2018, the situation was different. After 2018 February, the situation is different. How it became different? Then to receive money from the companies, how the system brought in new laws. Now we talk about the electoral trust. There are two varieties in which political parties will be receiving money. Individual contribution was the source under 29B initially. Prior to this introduction of electoral bond scheme, electoral parties were receiving money. They have been giving the accounts to the income tax department as well as to the chief election commission after every elections. This was the situation. In 2018, a new scheme was introduced that is called the electoral bond scheme. Now we will discuss about that. Electoral trust can be formed under 13B of the Income Tax Act 1961, where the electoral trust which is formed can receive money from the companies, and from the trust, the amount can be given to the respective political party. The respective political party will receive the money. Whatever is being received from the company, it will be given to the respective political party, whichever the trust feels, or what is the mandate given to the trust. According to that, 95% of the contribution, that is under section 17CA of the IT rules, 1962, 95% of the contributions to be donated to the parties, and 5% will be kept for the internal affairs of maintaining the trust. As far as the electoral trust is concerned, I feel so far there are about 8 to 10 trusts formed for this purpose. And the other point is transparency in the funding. Under class 9 of section 17CA of the IT rules, political party give receipt on trust for the amount received. So whatever is the amount received, they have to give the accounts for the same as per the electoral trust. This is electoral trust on one side. Then the electoral bond. Electoral bond is the new scheme which was introduced in 2018 in February month, and the then finance minister was there with certain amendments in the Income Tax Act, Companies Act 2013. There is an amendment, then RBI Act and the Representation of People's Act. Certain amendments were made for the purpose of introduction of this electoral bond scheme. Then, confidentiality of the donor company and the receiving political party be maintained. The main object of this electoral bond, according to the government, was at the time to say that there was more of unaccounted money, black money, that needs to be curtailed. By introducing this electoral bond scheme, it will be curtailed. And it has gone to the extent of saying this is an electoral reform in the system of elections. And they have put a cap saying that a receiving party ought to have secured 1% of vote in the previous elections, whether it is registered or unregistered, whether it is registered or recognized. Registered and recognized. 1% is the mandate eligibility criteria to receive money through this electoral bond scheme. Then all the donations shall be made through only bonds on digital or even check or DD, whatever it is. It should be accounted. No cash will be allowed, and that is the system in which the electoral bond was introduced in 2018. Then the major difference between this electoral trust and electoral bond is the company itself can donate money to the political party as far as electoral bond is concerned. Electoral trusts are concerned. company will give to the electoral trust, and in return, the electoral trust, for the purpose of which it was created, will give money to the donate to the political parties. This is the difference in both of this. And there, in the electoral trust, the accounting has to be given, whereas in the electoral bond, it is not necessary. The company is giving it to the political party. Under such a situation, it was challenged before the Supreme Court. This electoral bond scheme was challenged under Article 32 of the Constitution of India in the case of Association for Democratic Reforms versus Union of India 2024 SEC Online SC 150. The case, it challenged the very scheme, electoral bond scheme of itself, and it says that section 31 of the RBI Act, central government may authorize scheduled banks to issue bonds. Prior to the amendment in 31, it was only the central government and the RBI will alone have the powers to issue bonds. Now the central government has extended its arm to say that it will be given to the bank, any bank as preferred to issue bonds. In this case, it was being given to State Bank of India, SBI, to issue bonds in the nomenclature of 1,000, 10,000, 1 lakh, 10 lakh, 1 crore. In such a manner, the bond will be purchased by the company that will be redeemed by the political party. This is the modus operandi in which the electoral bond scheme was working. Then 29C of Representation of People Act 1951 to show accounts. Political parties not to reveal the amount received by way of electoral bond. So 29C is the class where the political amount, whatever is the amount received from the company, from any company, the political party need not reveal whatever the amount that is being given to them, or the company also need not come to the Companies Act, the next page. And then section 182 of the Companies Act, there was an amendment to that effect, saying the company whichever has donated the money to any political party, they need not reveal the fact of that to any other person. So it says all companies except government and foreign companies can contribute. Who are already take the caps? Say that not all the companies. Government, this was already there even prior to 2018. Government companies cannot be giving donations. As far as the foreign companies are concerned, also cannot be given any donation. In the same way, prior to 2018, companies which are existing for 3 years and which are running on profit, out of their profit, 7.5% can be contributed to the political party. This was the prior to 2018. Now it is changed a bit by amendment of 182. Then section 13A of the Income Tax Act 1961, whatever is the contribution to the political party, already the political parties are exempted from income tax. Even the companies need not disclose the entire details of their donation to any other party. So this was done under class 7.4 of the Electoral Bond Scheme 2018 with an object of saying confidentiality of information of buyer of the bond will be kept intact. And then on the Article 32 petition before the Supreme Court, there were lots of issues argued on behalf of the petitioner, that is the persons who are challenging the case against this electoral bond scheme. What are all the points? Basically, whether non-disclosure of information under the electoral bond scheme is violative of the right to information under Article 91 of the Constitution. See, Article 1, right to information, whether it infringes Article 19.1, because there is a test. If there is anything in 19.1, if it is evading it is invading the provision of 19.1, then under only reasonable restrictions is to be seen. Then Article 19.2, whether it is affecting the sovereignty and integrity of India or the friendly states or whether it is affecting the public order or defamation, what if, whether it is any of these ingredients are affected or not was checked in the judgment. And then whether the unlimited political funding is violative of the free and fair elections. We all say the very opposite of election, it should be free and fair. Free and fair elections are only expected. Only then the democracy will stand. We all know that India is the biggest democracy in the world. So it is very, very essential and vital to maintain the same. So whether the test was done under Article 14 of the Constitution of India. And then there are various other points also which were discussed with regard to this case. Like if the party is not disclosing who is going to be the donor and how much of money is going to be given to the political party, then there is every reason that they may have some influence over the policy of the government. Was one side of an argument. And then the other side of the second point was it will pave way for bringing in black money through some other source to the company, and from the company they may again donate to the political party. There are various arguments from the side of the petitioner saying that for these following reasons, a violation under 19.1, a violation under Article 14, and for various other reasons, the electoral bond scheme should be declared as constitutional was the claim of one side. On the other side, the union government, which brought in this electoral bond scheme, defended, saying that this is intervening into the economical policy of the government. And the main object behind this was to eradicate black money from the system itself. Because in the name of political system, people are bringing in black money and doing all those. That needs to be curtailed. Only as a reformation to that, the system of this electoral bond scheme was brought in, and various other arguments were also kept before the Supreme Court. The Supreme Court, on careful examination by a constitutional bench consisting of 5 judges, had come out with a judgment. Then, while discussing on the Article 19.1a, it said, right to information of voter is directly contrary to right of informational privacy of contributors. Because, see, right to information is the key. People of this country are supposed to be knowing on each and every aspect of what is happening in the election. On the one hand, when Form 26 is filed, the candidate is supposed to be saying on how many criminal cases and what are all the details on properties and everything. When that right to information is available with the voters, the same manner, they should also be aware of the donations given to the political parties. So therefore, it is not in public interest, and it is 19.2 does not talk about public interest. Therefore, 19.1 is directly hit, and it goes for a test also in this. And then Article 19.1 shall be restricted only for a reasonable restriction under the 19.2. Under the reasonable restriction under Article 19.2, it is not at all touched upon. Therefore, public welfare is not a ground under 19.2. We all know that 19.2 for Article 19 falls under the fundamental rights. Even then, it doesn't talk about the public welfare. Then, they say that it may lead to creation of more shell companies, as loss-making companies are also allowed to contribute. As I said earlier, even companies with the prior to 2018, a company should be 3 years old, should be running on profit. Only out of that profit, a minimum portion of 7.5% of the profit amount can only be given to the government. But now it has been removed. That was another concern during the argument. Then, while this question on 19.1 was put into the judges of the Supreme Court, they said, doctrine of proportionality shall be applied. Whether whatever it is being done on the scheme, whether it is proportional. On the same test, they do apply to test validity of any legislation. Article 19.1. The test includes legitimacy, suitability, necessity, balance. Then these are all the four ingredients for the doctrine of proportionality. With that, the ultimate balance test to check between two conflicting fundamental rights. On the one hand, the right to information is lacking. On the other hand, they say it is an electoral reform. The least restrictive means to restrict one fundamental right over another fundamental right. When there are two fundamental rights, each other facing one another, then the test of ultimate balance test is conducted under the doctrine of proportionality. Then it was found that ultimate balance test, they did not find more merits on Article 19.1. Therefore, along with 19.1, they also tested Article 14 on electoral bond scheme. 2018 was considered as quid pro quo, a favor in exchange of another favor. That is, let us assume a company which is donating an X amount to any political party. Now, they say that political parties have lots of gaps. They will be coming to know about the amount donated, which company donated, how much they donated. So for that, as a quid pro quo, they also have to do something in return to that. So they will be doing some favor. See, the argument goes further saying that because of this, some policy changes, some other advantage may also come to the party, and there is no level playing field between the political parties. Suppose A and B parties are there. A party has only a very minimal money with them to fight the elections. Whereas if it is a B party or C party with more money, with more financial strength, they will be able to face the elections with much more strength, and the election will not be in the equal platform. Therefore, it will be directly hitting the Article 14 of the Constitution of India. That was an argument placed before the Supreme Court. The scheme was used as a level playing field by the recognized political parties. They say, suppose if I start a new party tomorrow, I will not be able to meet a level playing field against the other political parties. After all, we are a democracy, largest democracy in the world. And when we have to fight the other political party with their money power, it is very difficult. We are not having a level playing field. That is the reason why they have gone more deep into analyzing the Article 14 on the light of this scheme. This legislation do not have a real purpose, but only an ostensible purpose. It looks as if there is a purpose, but indeed there is no big purpose that could be seen. Was an argument to strengthen the political parties. And then there the doctrine of manifest arbitrariness is applied. There it was ultimate balance test in Article 19. As far as the Article 14 is concerned, doctrine of manifest arbitrariness is applied. What does manifest be arbitrariness? A legislation shall be irrational, capricious, without adequately determining principle. What was the principle in which the scheme was derived? Equals are not treated equally as per the doctrine of intelligible differentia. If we have the same, suppose if the political party is there, when it comes to face elections, they have to be in the same platform to face it. That is lacking there. Therefore, Article 14 is also hit. As far as 19.1 is concerned, 19.1 right to information is not there. Here, equals are not treated equally. On these two main points, the Supreme Court, even though considered many other points, had struck down the electoral bond scheme, and then it declared it unconstitutional as it is beyond Article 14 and Article 19 of the Constitution of India. For the various, even though there are the befitting argument by the government saying that it is an electoral reform one and it is an economical policy of the government. On the policy, court should not be interfering. And they gave various judgment in strength of their argument. In spite of it, the court felt that it is hitting the Article 19 and 14 and it is beyond the article. Therefore, the court held that the electoral bond scheme was unconstitutional. So there, how the funding was done and how this electoral scheme and electoral bond came to an end. Electoral trust, there is no issue on that. But electoral bond scheme is concerned, was considered as unconstitutional. Thereafter, we all know that the Supreme Court has said to the State Bank of India to produce all the details to the Election Commission of India immediately, within 1 or 2 days. And it took 1 day, and the second day it gave all the details, and still that entire issue is there before the media and others will be knowing this. Then let's, on the topic of election, now let's go to this Article 80, composition of Council of States. How many members will be there as a Rajya Sabha members? We all know that Rajya Sabha members are elected through the Electoral College. That is, the elected members of the Lok Sabha and the elected members of the Legislative Assembly of all the states of India and the Union Territories. From the MLAs and the MPs put together, they vote and select the Rajya Sabha members. Now, what is the strength? The total strength, it cannot exceed 250 members. At present, it is 145 members in the Rajya Sabha. And then the 233 members elected by indirect elections and 12 members are nominated by the president. In electing them, 12 members can be nominated by the president. Then the Article 81, composition of House of the People. House of People is Lok Sabha. How many persons can be elected? Not exceeding 550 members. Presently, we all know that there is 543 members. 530 members from the states and by direct elections, and 13 members from Union Territories by elections. So all put together is 543. 530 from all the states and 13 from Union Territories. They are elected, and on their elections, they become MP, member of parliament, and they go and form a government with a majority. Now, about the elections. See, the election, once if the code of conduct is started, till its end, the code of conduct will remain. The candidates belonging to the respective parties will be chosen, and they will contest in the elections by filing their nomination. They will become the candidate, and they will go for campaigning for this period 48 hours prior to election. This prior to 48 hours, they have to stop all their campaign. There should not be any other activity with regard to election, either in the television or in person or through mic or going around, should not be there. That is called silence period in election. The 48 hours is given to the people, and this practice has been followed across the world. It is an international practice. Section 126 of the Representation of People Act 1951 restrict any political party to convene, hold, attend, join, or address, display, and propagate public meetings in this 48 hours. This very crucial time. Within this 48 hours, any political party does anything that may sound very fatal to the political party. Therefore, everyone, it's a silence period maintained by all the political parties. And then, once if the voting is done, in all the booths the constituency, whether it is parliamentary constituency or it is a legislative constituency, the booths, whatever there can be 1,000 booths for one constituency. All the booth, the machines, the VVPAT machines, will be collected in one particular place, or sometimes maybe two, under the supervision of the returning officer. Normally, it will be in one place. All the the VVPAT machines will be brought to one place. That is normally the headquarters of where the RO is present, because they are the persons in charge of the entire elections, right from the nomination till declaring of the elections. It is the duty of RO. So, who will conduct the votes? Who will count the votes and declare results? It will be in headquarters under the direct supervision of the returning officer. The counting shall take place on the prescribed date. How this counting will happen? I've just given the diagram to show that how the counting assembly will be there, how the counting agent also will be there from all the political parties. If whoever has been nominated as the counting agent can be present, and they can also watch what are the proceedings. Round one, round two, like that the counting process will go, and we all have seen that. So depending on that, the election results will be announced and a certificate will be given by the RO, and declaring that this person has been successfully elected as a member of parliament, as a member of legislative assembly. Depending on that, till you get that certificate, it is not sure that you have won the elections. We have seen that also in previous cases. Sometimes the media may say various things. Only when the certificate is given, it is declared, given the certificate, then it is confirmed that the person has been elected for that particular election, whether it is parliamentary election or legislative election. Then, what is the importance, the percentage of, I think the webinar's object also travels only in this direction. Make sure that 100% of voters go to the booth on the particular day, cast their votes. This is the main mandate of our V2 legal team in presenting this webinar. See, on the same line, we analyzed this and we could see the first election was in 1951 to 52. The percentage of votes secured is 45.67%. And then in 1957, slowly grown, it shows 47.74. In 1962, it is 55.42. In 1967, it has grown to 61.04. And then in 1971, 1967, 61.04. There is a downtrend. That is in 1971, it was 55.27. 77, it was 60.49. In 1980, it is 56.92. 1984-85, it is 64.01. And 1989, 61.95. And then in 91, it is 55.88. 96, it is 57.94. In 1998, it is 61.97. In 1999, it is 59.99%. In 2004, it is 58.07. In 2007, 9, it is 58.21. It is in 2014, it is 66.44%. And in 2019, it is 67.40. In 2024, we expect it to be 100%, so that the endeavor made by the Election Commission of India, as well as the will and wish of the people, will be fully fulfilled if all the voters, they go to the booth, because it makes a huge difference. Now, the selection process is happening with only 65%. Whoever gets 35% or 36% becomes the winner, and they choose it. The government is done in such a way. If the 100% is coming for voting, then the situation may differ. We will not know what is going to be the result. But at the same time, we all will have the satisfaction that democracy is working to its fullest extent. Then, what are all the qualifications of a member of parliament? Article 84 of the Constitution deals about it. A person shall not be qualified as an MP unless he should be a citizen of this country. In case of Council of States, not less than 30 years of age. In case of House of People, not less than 25 years of age. And there are such other qualifications as determined by the Parliament from time to time. The age limit has been given. Like how it was for the voters, it has been given. Initially, it was 21 years. Then it is reduced to 18 years. In the recent parliamentary debates, we come across parliamentarians saying that the voting right should be reduced to 16 years because nowadays the youth have become more vigilant and their exposure to social media and exposure to more of literacy is high. Therefore, the age should be reduced. There's another debate going on. We also expect that may also happen in the future. And then, what are the qualifications of a member of a state legislature? Article 173 of the Constitution talks about the qualification. A person shall not be qualified as an MLA unless he is a citizen of India in case of state legislative assembly, not less than 25 years of age, and in case of state legislative council, not less than 30 years of age. And then, selection of Prime Minister, President, that is discussed in Schedule 3 of the Constitution, which says oath, affirmation, and the term of a Prime Minister is for 5 years. Whereas in the case of President and Vice President, it is 6 years. And Lok Sabha members are is 5 years. Rajya Sabha members, it is 6 years. As far as the Chief Election Commissioner is concerned and the State Election Commissioners are concerned, it is all 6 years. Now, selection is governor term is 5 years. It is all Chief Minister is also 5 years. What is the single party forming government? We are all seeing that various political parties are contesting in elections. When it comes to forming of government, whether it is a legislative assembly, or forming a parliament, forming a Lok Sabha, House of the People, whether a single party alone can form a government, or government can also be formed by coalition. Now, we have seen in the recent case, Bombay, Maharashtra, single party forming government, the Subhash Desai versus State of Maharashtra, where Eknath Shinde has divided from Shiv Sena, formed a group and also formed a government in coalition with BJP and then also formed a government. So, it is needless that only a single party can form a government. Maybe by uniting with other parties also, the government can be formed and the representation can be given to the governor saying that he will be having the majority. Depending on the number of seats in that assembly, they have got majority, they can prove majority, then the government can also be formed. Then, appointment of chairman and vice chairman of Council of States in Article 89, appointment of speaker and deputy speaker of the House of People is under Article 93. Amongst the elected members of that Lok Sabha, they will elect the person, deputy speaker, speaker of, normally the speaker of the Rajya Sabha would be the Vice President of India. And then discuss the disqualifications. How a member of parliament can be disqualified, when he becomes disqualified. Article 102 discusses about disqualification. A person shall not be disqualified to be an MP if he holds any office of profit under the government of India or under the government of any state, if he is declared by any competent court to be unsound mind, if he is undischarged insolvent, if he is not a citizen, suppose a citizen, and then he takes the citizenship of any other country, then he will be disqualified. If he is disqualified under Schedule 10 of the Constitution of India, this Schedule 10, Schedule 10 plays a very, very important role in disqualification. You will see it in detail. How members of state legislatures are disqualified. As per Article 191, person shall not be disqualified to be MLA if he holds any office of profit under the government of India or under the government of any state, if he is declared by any competent court to be unsound mind, if he is undischarged insolvent, if he is not a citizen of India or have acquired the citizenship of any foreign state, he is disqualified under the Schedule 10 of the Constitution. And then when an MP or MLA is disqualified under anti-defection law, this Schedule 10 talks about anti-defection. Once if he is elected from one political party, he is expected to be loyal to that political party which chose him as a member of either the parliament or the assembly. In case he is not loyal for whatever reasons, he will be disqualified by making an application to the speaker of the assembly of the parliament. Paragraph 2 of 10th schedule says the reasons. Voluntarily gives up his membership of that political party. That is, maybe he may resign from that political party or abstains from voting. If he is elected from one political party, he is expected to vote in favor of that political party. Otherwise, he is doing defection, is doing anti-defection activity. Therefore, he should be disqualified. A representation can be made. An independent candidate joins a political party, then he is no more an independent, he loses the capacity. The reason, the logic behind this is this: when a voter is electing a person, the voter thinks that person in mind not only on him, also on the political party he votes. So based on which it is selected. Therefore, when he is not loyal to the party, then this situation is taken. The exception under paragraph 4, there are certain exceptions. Like Eknath Shinde's case, I said, when two parties merges, if A party has 5 seats, let us say 5 candidates, 5 elected MPs, B party has 200 MPs. If this 5 MPs merge with this other party, other political party, then it is not considered as anti-defection. Then, when a political party splits into two, let's take Eknath Shinde's case, where when the party itself is splits into two, and the split should be at least a minimum of 2/3 of the members shift to the other party, then it cannot be considered as anti-defection. That is within the legal framework of law. Therefore, that can be accepted. Then we discuss about the electoral disqualifications. We all see person is elected, he is serving the country or serving the state as an elected assembly member or elected parliamentarian. For the pending cases or something, if he is convicted, what is the position? Section 8, Class 3 of RP Act, Representation of People Act 1951. If convicted for an offence, up to 6 years, shall be disqualified from the date of conviction or order. For 6 years, he cannot contest in the elections. A person who cannot vote also cannot contest in election. And then I am reminded about one case in Venkatachalam VA. Says Swami Kannu, this is a very celebrated case in 1999, 4 SEC 526, vote impersonation. The person who contested in the election, the candidate, he does not have a vote in that constituency. Without having a vote in the constituency, he impersonates some other person as if he is that Venkatachalam, and he contests in the election, and he also wins the election. Thereafter, knowing about it, a writ petition under 226 of the Constitution of India is filed before the High Court. The case goes on the argument. It is found that there is a fraud played on the voters and the impersonation has happened. He can even go to the extent of filing a criminal case against the person. Therefore, the election is void, and the person who was elected as the person is no more an MLA, and the entire process of his selection itself has become unconstitutional. So, it is very, very important for everyone to be a voter first in that particular constituency if they are going to contest. Suppose he is not a voter in that constituency, he belongs to some other constituency, then he should obtain the certificate from the constituency in which he belongs, take a certificate from there, give it to this constituency where he is going to contest. At the time of filing the nomination itself, only then law is satisfied. Otherwise, if he does any other malpractice, then it becomes illegal and he will not be eligible. And then, what are all the articles that are touching upon election? From Article 324 to 329, these are all the crucial articles which discusses about election. How a chief election commissioner is appointed, what is a chief election commission, what are all the roles and responsibilities, who appoints the chief election commissioner, that is the president of India appoints the chief election commissioner. The state election commissioners are appointed by the governor of that state, and the tenure of their position as an election commissioner would be for 6 years, and the chief election commissioner is the chairman of the chief election commission. A question arises in the case of T. N. Seshan versus Union of India, 1995, 4 SEC 61. Whether the chief election commissioner is the superior officer, other election commissioners are below him. There is the case it dealt with. It said that all are equal in rank, no one is superior, no one is inferior, but the chairman is the chief election commissioner. Therefore, we've been coming across the election cases in various ways. T24, then 324-4, appointment of such other regional commissioners as may be necessary. Now we have the state state election commissioners who will be conducting the municipality, panchayat, corporation elections. And then 324-5, removal of chief election commissioner. Removal of chief election commissioner is like removing any high court judge. It is not so easy. It is a process which is to be followed like removal of the high court judge. And then in the case of Anup Paranwal versus Union of India, 2023, 6 SEC 161, it states that in selection of chief election commissioner, it is at present the prime minister of the country, the opposition leader of the country, and the union law minister all join together and choose the chief election commissioner. In the process, the Chief Justice of India has to be added. This is the case pertaining to the inclusion of CJI as a member in the selection committee. In the case of Anup Paranwal versus Union of India. And it is said that CJI has to be added. In the meanwhile, there is an amendment made to this which says Chief Election Commissioner and other election commissioner appointment, conditions of service and term of office in Act 2023. Before even that, there is an amendment to that section. And then Jaya Thakur versus Union of India is again filed challenging Section 7, including the CJI. and that is now sub judice. That is the position. CJI as of now, in that case, since now election has been declared, the Supreme Court do not want to interfere. Therefore, the evolution of election over a period and various factors have been happening in expenses, the manner in which it is happening, the technology people are using, it is on in the improving spree. And then Article 325, it talks about preparation of the electoral roll. On prior one cutoff date, the electoral process, who are all the voters, the entire electoral list has to be prepared. Principle of adult suffrage. That is, before 18 years, once the voter reached 18 years, once a person reached 18 years age, he becomes a voter. The election commission should take all sincere steps to see to that he becomes an elector and he comes as a voting person to vote. And then Article 327, Parliament shall make laws for delimitation of constituencies. Yesterday we saw about the delimitation. It is based on census, and delimitation is the process in which constituency is determined, how long it will be remaining as a reserved constituency, and what will be the area, how administratively it will be managed. Everything will be done that is on the basis of this Article 327. A delimitation commission itself is formed, and all the other work concerning to delimitation, census. We are seeing what is the census and how they have been demanding, the political parties are demanding caste-wise census, and all those things we are seeing. And then Article 328, state legislature shall make laws for preparation of electoral roll. As far as the cooperative panchayat and on the state legislative election, the State Election Commission should prepare the list of the electoral roll in their respective states. And then 329, when the cases are concerned, when the electoral cases, when the cases of the election are concerned, they have to be mandatorily filed before the High Court only. And normally, all the other courts shall not interfere into the validity of any law relating to delimitation of constituencies made under Article 327 and 328. Exception to this provision is filing of election petition alone before the High Court. For other reasons, challenging the election or other processes should not happen in any other court. Only in exceptional cases, if there are valid reasons for that, then alone it can be filed within some 30 or 45 days prior after the elections also. Then thereafter the election petitions cannot be filed. As far as the sections of 79 to 107 of Representation of People's Act 1951, it also discusses about the electoral offences like bribery, so and so on, and what poll rigging, what are all the other conditions in which any violation is happening in the election process. Then, what is an electoral right? Electoral right, very interesting to know. Under section 171A of IPC, right of a person to stand or not to stand, or to withdraw, or to vote, or refrain from voting at any election is the right electoral. It's the right the person has got. That is called electoral right of a person. That is given in section 171A of the IPC. And then Article 326 of the Constitution says about right to vote, and it is a constitutional right. So all the voters have to do their constitutional right of exercising their right by voting. Then what are the corrupt practices in the electoral offences under RP Act and IPC? Section 123 of the RP Act, corrupt practices, and section 125 to 136 of the RP Act deals about all the electoral offences. Section 171B talks about bribery in elections, and from 171B to 171I of the IPC, the offences relating to the elections have been dealt with. If there are other than that, any IPC offences like 147, 148, unlawful assembly, any other clash, that will be dealt by the IPC sections. And then we say for unreserved symbols, I think I may take with your permission another 10 minutes, I'll finish it. And then for unreserved symbols, for the symbols, They have to apply before the Chief Election Commissioner 6 months prior to elections. They are open to apply before them. See, the first election in 1952, 70% of the voters were illiterates. So it has become very crucial to make the voters first of all come for voting and make them identify with some nomenclature on how to vote. Therefore, symbol was introduced. There was Banyalal Kumar versus R.K. Trivedi, 1985, 4 SEC 628. First time it recognized the need for symbols as many people are illiterates and they would easily identify them. See, truly speaking, symbol system was introduced for the purpose of illiterates because they will not be able to read the names and easily identifiable. Therefore, the system was used. I came across a story of Maharani Gayatri Devi of Jaipur. She also became an MP at that time. And in her book, Princess remembers the memoirs of the Maharani of Jaipur, elections 1962. She says that she contested in the elections. Always people remember her with the symbols they have. The symbol given was a star. But the other symbols given in the list of symbols was in the elections, a person standing with a horse. Since they thought she is a queen, a horse is there, a person is standing with the horse. Maybe that is the symbol. Then there was a symbol of sun. The symbol of sun was denoting the king, it seems. So it is the king's symbol. Should we be voting for the king? There was a confusion, but at last somehow she has won the election. So she talks about the importance of symbols. Why I have said the story was it's very important. Symbol is also very crucial in the election process. If it is a registered party, recognized party, the recognized party will continue to enjoy the symbol. That gives them the extra mileage. And then, importance of a flag. Why a flag is used in elections? And why a party is using the flag? It will be an easy pictorial recall for the political parties to bring in the cadres in line so that the affinity to the party also becomes more. That is the importance of a flag, considered as a political and national representation. Sometimes it is a political, if it is a national flag, we all stand proud, honored, we see the Indian flag. The same way, every political party sees their own flags. They feel they connect with the political party very easily, even from a very long distance, or it's on the very vicinity of it. So it is used to establish an association between the party and people, create a common identity to send subliminal cues. Colors on the flag brings in specific emotions. They say even the colors have emotions, and the particular colors which are remembered in your pictorial mind, it will easily give you recall. See to that flags are important. And then any decision making also, the flags gives you the thinking and the thought process while doing your act. So it has got very impressive impression on the people. And then we know what the election is, the process, regular process in which we go and vote. And a by-election is if the constituency is declared vacant for various reasons. It could be death of a person, it could be disqualification of a person, or it could be because of anti-defection, the person has been removed under Schedule 10 of the Constitution. Whatever is the reason, if there is vacancy arising on the running, when the government is already there in room, then the by-election will happen. How long can a seat remain vacant? Normally, under Section 151A of the RP Act 1951, it says that Election Commission of India shall fill a vacant seat within 6 months. Normally, if it is a by-election, the person is not there. Within 6 months, the Election Commission should take all endeavor to fill up that seat. Then, with that, we are coming to a close. And now we are going to face the elections for the 18th Lok Sabha in the country as a dutiful citizens of this country. On 19/4/2024, we all will pledge to vote in the upcoming 18th Lok Sabha election and make our democracy more stronger and make the country proud, make the world feel that the largest democracy has exercised their duty dutifully. And I thank wholeheartedly each and every one of you for participating in this webinar by the V2 legal team. Thank you so much. And I'm awaiting to meet you in the next session on some other subject. Thank you.
Thank you so much for sharing your ideas of wit and wisdom, sir. It was truly inspiring. We, the V2 legal team, wholeheartedly thank each and every one of you who are able to participate in the webinar on elections yesterday and today. We hope that the entire session was engaging and educative. We do look for more sessions like this to share the knowledge to the legal fraternity and the general public. We take this as an opportunity once again to remind each and every one of you to make sure 100% of polling in the upcoming 18th Lok Sabha elections that would make the endeavor and social cause of V2 legal team great success. We will share the PPT presentations with all the participants. Thank you once again, and we look forward for the same participation in the upcoming session. Thank you.